Okay, so I think we can begin. Okay, so good evening and good afternoon, everyone. I am Silvia Casu, Deputy Head of the International and European Law Department of itinere, which is an Italian online law journal with more than 100 active writers publishing daily articles on several legal fields. And before starting our webinar, I would like to thank the European Affairs Committee of the New York City Bar Association for the collaboration, and in particular, Claudia Carbone and Jonathan Halpern, who will be our chairman today. I would also like to thank for their kind participation Dr. Joel Grogan, senior lecturer in law at the Middlesex University of London, and Professor Dr. Petra Bart, visiting professor at the Central European University in Budapest. So today, our guests will discuss the relationship between the state of emergency and the rule of law within the framework of the current COVID pandemic, focusing in particular on the rule of law situation in Hungary. So thank you again for joining us today. And I now leave the floor to Mr. Jonathan Halpern. Thank you.
Well, thank you very much, Sylvia, for the kind introduction, and to use in itinere. Apologies for my pronunciation, but on behalf of the New York City Bar Association and the European Affairs Committee, which I'm privileged to chair, I'm delighted to be with you and to participate and to listen and to learn from our very distinguished guests, scholars, and experts today. And to learn from you, the participants in the audience, because there will be significant opportunity from you to pose questions to our scholars and experts. And we invite you to do so after the individual presentations. I should say that it's good to be, even with a Zoom connection with you in these extraordinarily difficult and challenging and painful times, really for all of us. And it highlights the significance that we all play as members of a global community. And that has its benefits and opportunities, but it also highlights potential vulnerabilities and challenges. And I think today's topic could not be more timely or pressing. And that is, how is the rule of law and state of emergency, when aptly applied in dealing with a pandemic or other global threat, such as COVID-19, and with the spotlight on Hungary, how do we protect our citizens from this risk of health, from economic, the ravages of economy that is often suffers? How do we protect ourselves from one another? And how do we protect ourselves from an overreaching government in the name, perhaps, of acting as out of a state of an emergency? As our speakers will address today, they will also say that you don't need a declaration of a state of emergency for an abuse of power, but these are all timely issues. And what are the institutions that we have? What can they do about? What affirmative measures can they take individually and collaboratively? And this is, as I say, particularly timely. And how do we address these issues when the threats perhaps are affecting certain member nations and others more harshly than others? And how do we deal this with protecting individual civil liberties, where we recognize that others don't have the right to infect one another, but they do have perhaps the right under the rule of law and civil liberties to go about their business in terms of free association, freedom of expression, and so forth. So this is an extraordinary opportunity to bring these scholars and experts together who are steeped in experience and expertise in addressing these issues and writing on these issues. And so I would like to say, and it will go over the order of the presentation, but I should say at the outset, as part of my duties, that the City Bar and the European Affairs Committee are participating in this program as part of an educational and informational exchange. but it should be clear that neither the program nor the views of the speakers or panelists, or for that matter, any of the questioners, do not convey or reflect official city bar positions or committee positions. And those statements, of course, should not be construed or interpreted that way. So without further ado, let me present the order for today's afternoon and the evening's presentation. First, we will hear from Professor Joel Grogan, who will address issues relating to the state of emergency and rule of law, exploring the broad implications of COVID-19 pandemic on, among other things, human rights. Implicated are issues of extraordinary powers, ordinary law, declarations of a state of emergency, limits of executive action, impact of COVID-19 on democracy, justice, and human rights. So very small topics to cover in 20 to 30 minutes. After Dr. Grogan's presentation, as we say, there will be a full opportunity for questions and for Dr. Grogan to respond. After Dr. Grogan's presentation, Professor Petra Bard will be focusing on the circumstances in Hungary with respect to democracy and rule of law, and with particular attention to Mr. Viktor Orban's Enabling Act, which grants the government the power to rule by decree, and the implications for democracy's effective control of executive actions and checks and balances. And finally, I think Dr. Bard will address the role of the EU and other institutions to work collaboratively to address these kinds of issues. So let me give a more proper introduction of Dr. Joel Grogan. Has an extensive credentials and experience. Dr. Grogan is currently a senior lecturer in law at Middlesex University in London. Her primary areas of research are UK and European Union public law, with an expertise on the rule of law. Her current focus is on Brexit and the legal measures taken in response to the COVID-19 crisis. Dr. Grogan has been the convener of a COVID-19 and states of emergency symposium, which has been very extensive, spanning something like 50 days, extremely prolific, with more than 80 contributions from more than 100 scholars analyzing states of emergency and the use of emergency powers in response to the pandemic crisis from the perspective of democracy, human rights, and the rule of law. In addition, she has been participating in large-scale and international research projects at Middlesex University, at Oxford University, and various related projects, including on the meaning and scope of the EU role of law, unity and diversity and national understandings of rule of law, and other such works. Prior to her appointment at Middlesex University, Dr. Grogan graduated with distinction from the BCL at Oxford University. She completed her doctoral research on the rule of law in the European Union at Oriel College of Oxford. And she completed her undergraduate degree in law at Trinity College, Dublin, where she was elected a scholar of the university. And last, but by no means least, she is the creator, and this is particularly appealing to me, of the Sticky Tricky Law, an online legal education project aimed to make complex legal concepts related to Brexit, the EU, and the UK legal system accessible and understandable to the wider public, including, I can say, to me and to many of us Americans. So thank you and welcome. Thank you, Dr. Grogan.
My gosh, I'm really glad that I can't blush right now. You should never make a ginger girl blush. It's very embarrassing. So thank you so much for what has to be one of the most incredible introductions I think I've ever had to a panel. So Jonathan, thank you. That was lovely. I will say just in a short note in my other project, so Sticky Tricky Law, where I draw cartoons on Post-it notes. I actually have an explainer of the rule of law for a non-legal, non-academic audience in 1 minute and 30 seconds, which is now up on YouTube and Facebook for anyone who's watching from Facebook. But I will say that I have been told with reliable authority from legal academics that it would take a legal academic to be able to keep up with the speed of an explanation of the rule of law in 1 minute and 30 seconds. So I do dare anyone who does not have a legal education to see if they can keep up with that video. But also thank you so much for the invitation to talk about what is a critical issue and what is an ongoing issue. So in the context of what I'm going to spend the next 20 minutes talking about, it's the findings, the clear findings that we've had from what was a global study of the use of emergency powers and states of emergency across the world. Just to give a little bit more context of the wonderful symposium that I ran with some incredible contributors from throughout the world, it's COVID-19 and States of Emergency, which is now published entirely online on the Verfassungsblog. It included 74 country reports, which covers about 80% of the global population. We asked all of our country reporters to tell us about constitutional provisions and legal provisions in terms of states of emergency and the use of emergency powers, but also, and very importantly, what powers had been used and what kind of emergent consequent or actual issues in terms of democracy, rule of law, and human rights had then arisen as a consequence. So what I'm going to be talking about is essentially what we've learned, what we've seen as either common practices and also common concerns throughout the world. In terms of the framework of what I'm going to be talking about, I'll start off by talking a little bit about ordinary legislation. So states that have relied primarily on health acts rather than emergency powers or states of emergency as we would recognize. So the ordinary use of power and the kind of concerns that have arisen as a consequence. I'll also talk a little bit about states of emergency. So when states have entered into usually very, very specific legal context for state of emergency, what that means. I'll then focus on executive action, which is somewhat cross-cutting between both those states that have relied on ordinary powers and also those who have engaged with states of emergencies and powers that have arisen under states of emergency regimes. I'll then talk a little bit about competence, because it seems to be one of the key and critical issues that are dividing a lot of international and federal actions as regards the COVID-19 crisis. I'll finish off with one of my favorite topics, which is trust, transparency, and the rule of law. So some very strong, good practices that we're seeing, not only within the context of states that are doing very well, but also states that are not doing very well. And I'll finish off with talking about urgency and good practice. There is a lot of debate going on, especially because a lot of countries throughout the world are now exiting states of emergency or thinking that they're coming to the end of the most serious crisis point of the COVID-19 emergency. And as we do so, we can now start reflecting on the type of law that we have and the type of law that we've engaged in the context of the COVID-19 crisis, and start to discern whether or not there are good practices from which we can derive and reform our law in future. That's broadly the framework of what I'm going to talk about over the next 20 minutes or so. So first off, when we talk about ordinary legislation versus states of emergency, there tends to be a very common concern, actually a common assumption, which is because emergency powers and the kind of powers that you can engage in a state of emergency are, well, can be so concerning. It's this idea of emergency perpetuates emergency. As soon as executive powers have the experience of using emergency powers, which have more limited oversight and can often be justified on the basis of necessity, that we might see more abuse of power in the context of a state of emergency. And certainly within the context of a lot of the findings, we can see a lot of states have tended towards an overuse or even abuse of emergency powers. But the very important qualification on that is having a state of emergency or existing or using powers that already exist within the ordinary law makes a state no more or less likely to abuse them. We've seen absolutely no correlation between states who have engaged with states of emergency versus states have only engaged with ordinary powers and the likelihood of abuse. Now, there are many different reasons that we can think about. The first is that simply existing health legislation provides the requisite powers, the requisite capacity that state organs and state institutions need to address the COVID-19 crisis. Now, one thing that we've seen right across the world, be it in what we would consider established democracies or even concerning authoritarian regimes, is very similar practices. Lockdown, wash your hands, even potentially wear a face mask. But the ways that they've been approached have been very different. And the context of states that have relied on ordinary legislation, one of the first concerns was most of the legislation has actually been quite out of date. It was written in a time that didn't take account of the mass globalization, the mass travel, even the mass information and movement of information that we now have. For example, I think in India, the ordinary legislation that was quite initially relied on, I think, was British colonial. It was from the 1860s. So when we think about ordinary legislation, one of the concerns is not only this law was written in a different time that is unsuitable to current practice, but from a legal and especially rule of law perspective, one of the critical concerns is that the use of powers under ordinary legislation is ultra vires, that they're pushing law beyond its intended use. Certainly within the context here in the UK, we've had a very difficult, shall we say, we've had a lot of, we've had a lot of legal certainty concerns, but nobody needs to talk about what's going on politically in the UK right now. But simply in legal terms, in terms of the interpretation of the Health Act, which was from 1985, somewhat reformed in context of the SARS crisis, but the interpretation and the regulations being created by government under this act seem to be pushing far the boundaries of what can legally be used, translating the provision which allows a limited quarantine for a small group of people to be a nationwide lockdown with very limited number of reasons for exit of your residence seems to be pushing the law beyond its intended use. Now, one of the critical concerns when we talk about this is we are translating necessity for legitimacy, or we're translating good reason for doing something as legality for doing something. Something because it's urgent may be necessary, but it's not necessarily legal. This is one of the concerns that are being drawn out of it. But one of the other rule of law concerns that we're also seeing in the context of use of ordinary legislation beyond engaging with emergency powers is typically it will be less scrutiny. Now, in the context of most states that have engaged with emergency powers under states of emergency, it typically correlates with a higher degree of oversight. In most countries, if you have a framework for a state of emergency, it means that you have extra powers, you have more limited oversight in the short term, but in the longer term, you are required in most cases to go to parliaments or to your national assembly and to justify the use of those powers. Those powers also need to be proportionate and have many other limitations. So the use of ordinary legislation beyond that tends to avoid that extra degree of scrutiny. However, this is not to entirely justify the use of states of emergency as somehow inuring or protecting executive powers or even state powers from misuse or abuse of law, because we've also seen quite critically in many situations an abuse of states of emergency. So very simply, a state of emergency broadly has 4 characteristics which are quite in common across the world. First, they're usually within constitutional texts, although other states also have them in just legal texts, like an act of parliament, for example. So typically they'll first have conditions for their declaration. They'll then have a certain delegation of power. They'll have then provisions for legislative or judicial oversight, and also limitations on their use by the executive. So the difference that we see across countries, and this is something that's critically important in the context of considering what is good law or what is a good legal regime in the context of states of emergency, is the type of design that we're seeing. Now, one of the surprising things, at least for me, when I was going through the reports, was there was no strong indication of whether constitutional safeguards can limit the potential for abuse of emergency powers. Now, the example that I can give is, for example, Mexico. So Mexico has a very, very good, robust design of emergency powers, but it's only been engaged, a state of emergency has only been engaged, to the best of my knowledge, once, during World War II in 1942. Now you can compare that with Egypt, which again actually still has almost a constant state of emergency. It has been in a constant state of emergency, I think, since 1967. In response to this near constant state of emergency and in response to the revolution, the Egyptian constitution was redesigned to try and introduce these constitutional safeguards, these parliamentary safeguards, to try and prevent that experience of abuse. Now, again, in the Egyptian constitution, as with many other constitutions, we again see a robust design of constitutional and legal safeguards on the use of powers and states of emergency. But as we've experienced, or as Egypt has experienced since 2017, there's still a near constant state of emergency because it's avoided. The provisions that require Parliament to extend a state of emergency are avoided simply by letting a state of emergency lapse for a few days and then recalling it. So one of the lessons that we're almost learning from the different experiences of states of emergency is good law is necessary, but it's not sufficient. Chile and Estonia have fantastic and very, very prescriptive prescriptive limitations on the use of emergency powers when a state of emergency is called. They also have the legal requirements, which they've followed through on, of notification to international human rights bodies. So under the ECHR or the ICCPR or the AHCR in respective countries. And they've done so. The Chile and Estonia have called a state of emergency in the context of the current COVID crisis. And yet we're also seeing in both of those countries a very active, almost avoidance of parliamentary scrutiny of the emergency powers and their use in the context of the COVID crisis. So the reason that I'm emphasizing the concerning aspects of both ordinary legislation and the use solely of ordinary legislation and also states of emergency is to come to a rather sad conclusion for me as a lawyer, which is good law is important. As I said, good law is necessary, but it's not sufficient. This is certainly something that I know that Petra will be picking up on. As a third point, and just to focus on when we become concerned. So why is that key point of concern in the context of emergency powers? Well, essentially, it focuses primarily on executive action, that we will often think that due to the urgency of action that is needed in emergency conditions, executive measures shouldn't and don't undergo the same degree of scrutiny or stages approval that we would expect of law. Urgency can mean necessity, but it should never mean impunity. One of the really concerning aspects that we've seen throughout the world is a lot of executive powers, and this again relates to that emergency perpetuates emergency, and having limited oversight is wonderful if you don't really want to justify your decisions to any other bodies. But one of the concerning aspects that we're seeing throughout the world is government policy being introduced through the guise of necessity. We're seeing, especially in the context of an increasing criminalization of misinformation, that this misuse of power to create a situation or create a power or a measure that can be used against political opponents. The reason that I highlight the criminalization of misinformation, which we're seeing in many countries throughout the world, from South Africa to Turkey to Malaysia, but also in Hungary and Poland, is that it's very concerning as it's requiring or it's stopping a very important voice of criticism. And it's a very, very important point of information about the content, about the COVID-19 crisis. We're seeing it targeted not only against journalists reporting on government measures, but also against doctors trying to report figures. The reason that we become so concerned about executive action is it can be very easy to justify action in an emergency. But unless you have requisite oversight, not only in terms of parliamentary oversight, but also in terms of judicial review, this leaves open for unlimited abuse. That takes me to a very important counterpoint, actually, which is competence. There's a very, very strong distinction between urgency of action and also non-action. The 2 points of non-action that I'd like to highlight is first, as we've seen in 2 federal states, we've seen in the US and Brazil, we've seen a very strong sense that COVID was not a serious issue, a sense of denial as to the reality of its impact. Now, in terms of most federal systems, and the US and Australia are very important exceptions to the rule, emergency powers are usually concentrated at federal level, but there's also very important response elements that are delegated to local powers. Now, as I've often argued, that there is a very, very strong rationale for the localization of emergency response. There's an expertise there, and there's also a capacity for urgency there. But the success of the localization of response in federal systems, and also comparably in international systems such as the EU, is it must be paired with a national response. Something that we're seeing throughout the world is when you relegate responsibility to respond to a crisis to local or regional levels, this can not only create uncertainty as regards the movement of people between those different regional levels, but it also creates an extreme confusion and disparity in reaction. Rather than it being someone else's responsibility, it just compounds crisis. The reality of non-reaction or late reaction, which tragically is being seen not only now in Brazil, but also in the US and here in the UK too, is if you do not respond quickly, if you do not have urgent reaction paired with strong institutional supports to support that urgent reaction, you tend to have the most negative outcomes. I say that within the context of the UK, as I wrote the UK report, and what was startling to me in the context of this was comparing how delayed the UK reaction was as compared with the rest of Europe. The UK has the highest mortality rates in Europe. It actually had one of the highest mortality rates in the world. And the difference was 10 days. When our nearest geographic neighbours, Ireland and France, were introducing lockdown measures on the 13th of March, 12th of March, we were suggesting that people maybe don't go to restaurants, but that's absolutely up to you. There was an 11-day difference in response, and we're seeing it. We're seeing it in mortality rates. To go to a somewhat more positive aspect, one of the most important things for me in terms of what I've seen is that state policies, which are based on legal certainty, on transparency, on clear communication, but critically on urgent action, have correlated to the best responses or best outcomes. I'm not only pointing at New Zealand and Denmark and Norway and Ireland in this, but also, interestingly enough, in Mongolia. They had one of the earliest reactions and clear communication as regards what was expected. They have the soonest lifting of restrictions and the lowest mortality rates. Those kind of key indicators that we're looking for in terms of good reaction. It's that if you comply by the rule of law, those simple principles of certainty, of transparency, of legality, it is better outcomes. There are better outcomes. The final lesson, as I realize that I'm speaking a lot because this is my research and this is what I'm living and breathing right now, is actually a very important lesson that we can derive from Italy. Italy was one of the hardest hit, most severely hit in Europe. It had experienced one of the highest, it had experienced actually the highest mortality rate outside of China initially. And the response of the Italian state, regional, local governments was one of legal and regulatory chaos. There was a propagation of a huge number of different decrees as everyone was scrambling to figure out what was going on and how to respond to it. It was a crisis of the rule of law. But one of the important, in fact, the most important response of the Italian government was to listen to criticism and to reform. There was a lot of external engagement, not only by, I point to the audience as if, yes, you were one of them, But there was a fantastic response in terms of academia, in terms of law, in terms of judiciary, in terms of broad stakeholder engagement. There was a reform of the law. The key lesson of the Italian experience, and I'm going to defer to our wonderful organizers who are actually in Italy, not here in the UK, is that urgency and urgency of action is the first port of call. But reform of law in light of developing situations and also in light of external stakeholder expert engagement is the key to having best outcomes. So respond quickly is the ultimate lesson, but respond thoughtfully thereafter. So thank you. As you can tell from my enthusiasm, there's so much to talk about in this context, and I'm very, very happy to take any questions.
Well, thank you very much, Joelle, for that very impressive, articulate, and compelling presentation. And I welcome, reach out to the audience to pose their questions through the Q&A feature that we have. Let me go back to a few things that you've said from the outset, and that is with respect to ordinary legislation. One of the concerns and possible threats is that the application of ordinary legislation has extended beyond its intended use. And so how do you make that determination? Do you go back to what we call here the legislative history? Do you go to kind of precedential decisions? How is that determination made? Presumably by the courts through judicial review. But what is the kind of the step-by-step approach that should be taken to assess whether ordinary legislation is being applied according to its intended use or is otherwise being abused?
Really an excellent question. It's linking to a lot of wider and critical concerns, which are essentially what I keep referring to in terms of oversight. So in the context of the UK, we had a very we had a very complicated system because we had a Coronavirus Act, which didn't give legal power to the regulation. Instead, we did have this reliance on the 1985 Act. And just the ordinary reading seemed to imply that it could be ultra vires. But of course, in the context of ordinary blogging or in terms of panel discussions, me saying that it looks ultra vires is very different from it being ultra vires. It actually links exactly to what you say in terms of judicial review. Now, with full acknowledgement that the capacity for judicial review, the competence for judicial review is very different in each system, we still do see a lot of debates going on as to the position of the courts in the context of the COVID-19 crisis. The first question in terms of the review of power and the emergency powers, or even emergency legislation where constitutional provisions allow review of primary legislation, for example, that doesn't really exist here in the UK, but it does exist in Ireland. One of the first questions is going to be the intensity of review. And in questions of intensity of review, inevitably, we're going to be talking about proportionality. And proportionality is usually determinative in many systems as to whether or not the use of power was justified. But that doesn't quite go to your question on, well, looking at the law itself, is it ultra vires? But one of the key stumbling blocks, and stumbling blocks is probably the underplay of the century, the understatement of the century from my sense in what I'm about to talk about, is a lot of courts have actually been stopped from having any power of review over provisions as regard COVID-19. I know that Petra is probably going to be talking a little bit about the courts in Hungary, so I won't. But for example, in Flylands, there was an ouster clause, which precludes any degree of administrative review over regulations that are being made. Absolutely no review being allowed. Whereas other constitutional or Supreme Courts are actually having an almost existential crisis as to whether or not they are permitted to even consider the question of when emergency powers can or cannot be used, or even looking at the interpretation of those provisions. So one of the very, very important questions that we're going to see being played out in courts across the world in the coming months and years. And so far, to the best of my knowledge, we've only seen early cases in Romania and the Czech Republic, is whether or not courts see themselves in a position to step in and make that determination of whether or not they're even permitted to consider oversight and judicial review of the use of these powers and also of that legislation. That first step, which isn't even talking about standing, that first step of whether courts are permitting the question is going to be critical. And that's before you then get onto the complicated questions of proportionality, intensity review, and, well, necessity of legitimate action. So very, very good question. Although you can tell I've been teaching that I'm beginning with very good question there.
Very good question. Well, there's some more questions that follow. You went in and you've identified the real and often fatal consequences of delay in action, including in the UK by 10 or 11 days. And so there's a tension between applying the ordinary law and then, as you say, making application to either Parliament or to a General Assembly to obtain a statute of emergency or an act of emergency. And how do you, in light of the pandemic, how do you try and bridge that tension between applying an existing rule of law, legislation, and then galvanizing the popular will or through its representatives in time to obtain the appropriate authorization or emergency power to get the job done, to whether it's a quarantine, a lockdown, or engage in any other measures to protect against the ravages of the pandemic.
I like that phrase, get the job done. So again, a very, very important question as regards, well, you know, Joel, you're talking about urgency of action, but how can you determine that? So one thing, and this is probably an obvious point, and it's actually perfectly evidenced from the fact that I'm sitting in London, you're sitting in New York. I know that Petra's in Germany, and we have lots of people in Italy, is we have access to an incredible wealth of information. The reason that I highlighted Mongolia, and one of my greatest regrets is we didn't have a Mongolian country report as part of the Verfassungsbook Symposium, is because Mongolia was looking at what was happening in China, and all the measures that we introduced here in Europe in March, they had introduced in January. We have access to information at a speed that we've never had before. Being aware of especially global emergencies is critical. One of my points of criticism, if I'm allowed to have points of criticism, is the slow reaction here in the UK is unjustifiable because we saw what was going on. We saw Italy for weeks. We are not on the other side of the world from Italy. We are about an hour and a half or 2 hour flight from Italy. It's unjustifiable to say I was not aware of a crisis coming. However, that doesn't, that's all political opinion and cannot be cited. Instead, to focus on the legal question. Very importantly, in the context of the legal question, is we saw almost every state responding with ordinary legislation, ordinary powers initially, and then going through the stages and steps to a state of emergency. The important thing in terms of state of emergency is the definition. Remember I talked about the different criteria that tend to be common? Well, the conditions for what constitutes a state of emergency are entirely dependent on each country and usually influenced by the history of that country. So for example, very, very few refer to a health crisis or an epidemic. In fact, very, very few. I think I could probably count them on one hand. But the majority of countries will refer to internal or external aggression or war or armed rebellion. The states of emergency and the conditions for triggering a state of emergency are usually very prescriptive and usually based on quite violent history. Except for, I think, Malaysia, which said anytime the king thinks that it's a threat to the security, economic life, or public order, then, you know, it's a state of emergency. So when we talk about triggering a state of emergency, it's first, have we experienced the situation before? And can it fit within the expected conditions for that triggering? Now, in terms of political will, this comes to a critical point, which is almost the overarching one, which is also why I kept emphasizing you can have fantastic legal regimes. You can design the best constitution possible. But if your political ecosystem does not support commitment to the rule of law, commitment to democracy, and commitment to human rights, it's just words on paper. So in terms of triggering an emergency, you need to have sufficient infrastructure there, both political, economic, also health, because we shouldn't forget the reality in this whole situation, which is if you have a wealthy system which supports public and social health care, you tend to be a bit more likely to be able to respond to a health crisis. But unless you have those supports there, political will becomes the second question. You can have all the will in the world to commit to responding to a crisis, but unless you have requisite law and political, institutional, socioeconomic supports, it's debatable.
Great. Let me turn, thank you for that. Let me turn to some questions by by some of our participants. Is in your discussion of the rule of law, do you take account, or to what extent do you concern yourselves with any particular Western or ethnocentric bias for that framework?
A fantastic question. I always feel that when people ask that question, I should announce the university I went to. You know, yes, my university, my heart was there for a long time. I'm not a huge fan of HLA Heart, but you know, he had great words. No, all of this to say, you're absolutely right that there should be an awareness that the rule of law has been understood as a very Western liberal democracy ideal. And in fact, I work closely with the Bingham Center of the Rule of Law, and they have a very prescriptive attitude when it comes to the core principles of the rule of law. And in fact, with my wonderful colleague Petra, as part of a larger research project, we've just published a working paper on core principles, core meaning of the rule of law in the EU. And we trace out those core elements. So one thing that I would say, all of this to say is, yes, I probably have a very strong Western liberal democratic bias as to what I understand the rule of law to be. But in terms of this project and this concept and this symposium itself, what I found was the principles or values, if you want to say, that seem to be determinative were not necessarily ones that you would only expect to see in that Western liberal democratic tradition. The idea of legal certainty, the idea of knowing what law applies to you, the idea of having that law apply to you, or in a way that is equal. These are not necessarily principles that would only be associated with Western liberal democratic systems. So while I do fully acknowledge that it's very important to be aware, especially as a legal academic, and especially speaking on global issues and global responses, that I can come with the weight of my Oxford education bias, a lot of what I ultimately found was these principles were not indicative of a democratic system or indicative of an autocratic system. You can easily say that the high public trust and the high degree of personal social responsibility that we're seeing in Denmark and Finland and Norway, which led to higher compliance with rules and regulations, can also broadly correspond potentially, and I haven't explored this, so again, don't quote me on this, but it could also be associated with strong compliance with rule following, strong respect for rule following in other traditions. So fully acknowledging that we should be aware of bias. In current times especially, we should absolutely be aware of bias. A lot of the principles that I talk about, a lot of the best practice that I've found are not best practice because that's the rule of law and that's my research, but instead it's clear operationalized ideas that lead to best outcomes. It follows that if I know what rules apply and if I understand why these rules are applying to me and why I need to follow them, that better outcomes happen, better outcomes come as a result. That would be my answer.
Thank you. I'm going to make one modification to this participant's question, and I hope and true to the to its intent. And that is in the legal framework that you've outlined and looking to the future, are you pleased with the role that courts play, and would you envision an expanded role or a different role for the courts or for judicial review in putting forward a more effective response to threats such as the pandemic?
That is what I would describe as a bear trap question, which is something that you have to tread so utterly lightly on, because any degree of weighty conclusion would immediately spring the trap. That was also the first time I've used that metaphor, and it actually worked through. I'm delighted. But no, the reality is it utterly depends on the system. It absolutely always depends on the system. That any of the conclusions that I'm drawing are necessarily practices that in general have shown better outcomes. Now, what I've always, what I've advocated in conclusion of these findings were not only that that legal certainty, that transparency, that urgency of action is correlating strongly with better outcomes. But one of the other aspects that I think tends to be important is oversight and review. So when I talk about oversight, I am talking about political oversight. I'm talking about, do democratically elected assemblies have the capacity and real power to give oversight over legal measures? Is there actual tangible capacity of these assemblies to prevent, stop, or otherwise review law? Does that exist? Political democratic accountability is incredibly important in the use and then ultimately reflective reform of emergency power. In terms of judicial review, which is that second part, I think it's important insofar as it's the way in which individuals can challenge the law. It's the way in which individuals who are affected by regulations, especially potentially the disproportionate or misuse of state power, have a capacity to challenge it. So in terms of the power of the courts and the place of the courts, I think this is a very, very important debate that we should always have in all democratic systems. That's an incredibly important part of the larger debate of the role of democratically elected systems, of political accountability, of legal accountability, of judicial accountability. It's not the sole focus though. So from my perspective, if you have robust, where you have very, very powerful executive action, if you have requisite political democratic oversight paired with requisite judicial oversight, that creates the strongest outcome. That creates the best outcomes, the best law. So for the bear trap question of what is the place of the courts, I will inevitably ask what country, when, and what other safeguards exist in a robust fashion within that system?
Well, it seems as though you safely averted getting ensnared in that bear trap of a question. So, you know, it was fascinating to hear your identification of kind of the paradox of Italy, where there was a serious, you say, almost multiple schemes of chaotic responses from provinces, locally, nationally. But to its great credit, they were very responsive in listening to the concerns and apparently sprung into action with great resiliency and resolve and mounted a terrific recovery. So what do you attribute that to? And so it looks as though that Italy is now in a promising position and emerging from the pandemic. You know, it's a slow and uncertain process, but that it has done so well. So what are the factors that you can attribute Italy's turnaround to? And what lessons can we all learn and draw from that?
I mean, the simplest lesson, and I think this is a nice lesson almost to leave on, which is its engagement with criticism. If the Italian government at all levels simply rested on the fact that it was an emergency and that emergency can justify any means of reaction, as urgency justifies emergency, then we would have seen more negative outcomes. We would have seen less certainty. We also probably would have seen less rule following. one of the critical concerns that I have right now in the context of this state is I'm not quite sure what rules apply to me right now, which gives me deep existential fear as someone who has built their life and their career on commitment to the rule of law. The ultimate lesson of Italy was engagement with criticism. It was engaging, and this also comes from Norway, it's engaging with these ordinary people and engaging with the experts, engaging with experts of all fields, not just health experts, but legal experts, constitutional experts. It's engaging with criticism. If there is one lesson to be learned in the reform of law and also in the creation of the best law, is you must engage and understand and reason with criticism. You must justify your position, because the governments who have come out every day and said, this is what we are requiring of you, this is what you must do, this is why we are doing it too, that's been the best law, that's been the best political reaction, that's led to the highest trust in government, and ultimately that's led to the lowest mortality rates and the soonest time possible that people have gone out and finally got a haircut.
Well, lofty objectives, and if we can all pursue that, it's difficult, obviously, to enforce, but just a very necessary framework as we all try to emerge from this pandemic. So, thank you so much for your insights and the clarity and presentation and a legal framework that I think has illuminated the issue of rule of law, ordinary legislation, emergency powers, and trust and transparency. So thank you very much, Joelle.
Thank you.
Let me turn to our next scholar and expert, Professor Petrobard, who will be, as we said, addressing as example of the spotlight on circumstances in Hungary, with a focus on the Enabling Act, and all in the context of democracy and the rule of law and those changes. Dr. Petrobard is a very distinguished scholar and expert in the field of criminal law, EU criminal law, criminology, and all things, I would say, now relating to COVID-19 and how those legal principles are tested. She currently serves as a researcher at the National Institute of Criminology. Since early 2010, she has served as the head of the Criminal Law Division of the National Institute of Criminology in Hungary, as a lecturer at the Central European University's Legal Studies Department. She teaches EU constitutional law, EU criminal law, and selected issues in criminology and forensic sciences. At ELTE School of Law, she teaches criminology and data protection law as well. And as a researcher at CEU, she has participated in various projects investigating the legal framework of biobanks, including their use for forensic purposes. She is the vice chair of the Hungarian Europe Society since 2003, and she has addressed in her extensive writings European constitutionalism, human rights in the European Union, the rights of persons living with disabilities, and judicial and police cooperation in criminal matters. Dr. Petrobard received her LLM in international business law and was awarded her SJD summa cum laude in the field of comparative constitutional law and received her PhD as well. So it is a pleasure and honor to turn to you, Dr. Petrobard.
Thank you very much for the kind introduction and invitation to share my thoughts with you today on the pandemic and the way the Hungarian government and the European Union handled it as such. Perhaps just one correction to be entirely safe here. I no longer work for the National Institute of Criminology, which is important because it belongs to the General Prosecutor of Hungary. So I don't want to have any misunderstanding that I'm affiliated now with a state.
My apologies.
Speak on their behalf, no problem at all. So my starting point is where Joël stopped, namely that authoritarians across the world are seizing the chance to introduce old and other creative measures under the pretext of the pandemic, from large-scale digital surveillance to doing away with national parliament, judicial control, freedom of the press. And indeed, extraordinary times might call for extraordinary measures, but they must never mean dismantling the trinity of the rule of law, democracy, and fundamental rights, which also have a special place in the EU legal order. So democracy is about enabling and conducting meaningful critical debates, and governments having to justify their actions. Now, this is only possible if people have access to information, scientific knowledge, cost-benefit analysis, impact assessment must constitute a central tenet and need to be inserted into a rational system. Even if a policy measure has been found to be effective in responding to the public health need, the wider ramifications must also be considered for it to be deemed legitimate in a democratic society. We have to scrutinize how it impacts the rule of law and how it impacts fundamental rights. Placing an emphasis on one policy or another is indeed a government prerogative, but the procedure culminating in making that decision should be transparent as well as open to scrutiny and regular assessment. Now, against this background, when people are frightened, they are ready to abandon rational decision-making and confer their most cherished liberties and rights to a father figure who claims to protect them, as we have seen in Hungary. Now, the Hungarian government came to the spotlight after passing the so-called Enabling or Authorization Act. But the claim I'm making here today is that Hungary, once a poster child of democratic transition, ceased to be a liberal democracy a long time ago. So pandemics, they don't create autocracy, they just reveal the system's true colors. Whatever rule of law index you are looking at, whether it's the World Justice Project Rule of Law Index, or the Sustainable Governance Indicators, or the Bertelsmann-Stiftung's assessment with regards to civil rights and liberties, or the Academic Freedom Index, or the rate of the implementation of judgments from the European Court of Human Rights, Hungary is either the worst or among the worst member states of the European Union. And last year, a point has been reached where Freedom House, for the first time since the democratic transition in 1989-1990, and for the first time in EU history, downgraded a member state, namely Hungary, from a free country to a partly free country. So the pandemic and the responses to the pandemic only made this shift towards authoritarianism more visible. So what I am going to do in the next 20 minutes or so is to give you an overview of the Enabling Act first. Second, I will show you what the government used the Enabling Act for. Third, I will talk about the repeal of the Enabling Act and the reintroduction of the second version of the Enabling Act. And finally, fourth, I will talk a little about EU responses to what's happened in Hungary. So first, let me talk about the background of the Authorization or Enabling Act. I use the phrase Enabling Act because this is what the Hungarian press and even Hungarian government politicians are using, even though it really invokes the worst memories of European past, because it really mirrors Hitler's 1933 Ermächtigungsgesetzes title, but anyway, apologies. This is the widely known term for the law, so I will just use the term Enabling Act for the remaining part of my presentation. So Prime Minister Viktor Orbán, he jumped on each and every political crisis since he got into power in 2010. For the second time after the democratic changes. There was a first Fidesz government between 1998 and 2002, but now I'm covering only the period after 2010. And first, it jumped on the so-called financial crisis. Back in 2010, when he got into government, he said that there was a need in order to tackle Hungary's public debt and in order to fight a wage war, to adopt a new constitution. This came as a surprise because constitution making was absolutely not on the agenda during the election campaign. But that was one of the first measures that the government introduced to come up with the idea of a new constitution, and under the pretext of a desperate need to tackle the financial crisis, a new rather controversial constitution has been adopted that is named the Fundamental Law. And in the name of the financial crisis, also the Hungarian Constitutional Court was prevented from reviewing financial laws, and this rule continues to apply today. 5 years later, in 2015, another state of emergency was declared due to the so-called refugee humanitarian crisis. As the law put it, there was a crisis situation caused by mass migration. Such a crisis situation can be declared according to the law if Hungary has at least 500 asylum seekers per day for a month, or 800 asylum seekers per day for a week. Now, this emergency since 2015 has been prolonged again and again up until now. It's still applicable today, even though asylum seekers can virtually no longer enter Hungarian territory. And indeed, an average Hungarian has never seen an asylum seeker in her life. Fast forward to 5 years later, 2020, the next war is waged against another invisible enemy, but this time a very real one, COVID-19. So the government declared a state of danger, which is a quasi-state of emergency, on the 11th March. And as a general rule, when a state of danger is declared, the government has the power to pass governmental decrees that cease to be in effect after 40 days, and prolongation of their effect can happen only for a limited period. Now, this shouldn't have been a problem for the government because Fidesz, the governing party, has a 2/3 majority in the unicameral Hungarian parliament. So they could have prolonged the scope, the timely scope of these decrees again and again. And what is more, the opposition parties were also in favor in adopting these governmental decrees, but they wanted to extend the rule by decree only for 90 days. Prime Minister Orbán, however, wanted more. In the end of March, on the 23rd of March, he introduced, and the 2/3 majority of the parliament passed the so-called coronavirus law, the Enabling Act, on the 30th of March. Lawmakers envisaged in this law that the Hungarian parliament at some point during the pandemic might not be able to convene. They didn't dissolve the parliament, but they foresaw that such a situation may emerge. So therefore, they introduced the rule by executive decrees without any sunset clause, that is, for an indefinite period of time. And the decrees that have been adopted, they didn't have to be prolonged after every 14 or 15 days respectively, but they were supposed to be in force until the emergency is over, which, as I said, was declared to be indefinitely. So it's called, the law is called Enabling Act because it enabled the government to rule by decree, virtually giving the government a carte blanche authorization for the future. Midterm elections and referenda were banned during the state of danger, even though the government claimed that every measure that is adopted under the Enabling Act is temporary. Despite this fact, some permanent changes were introduced into the criminal code. So, for example, anyone who is spreading a falsehood or distorted truth in relation to the emergency in a manner that is capable of alarming or agitating a large group of people is to be punished by 3 years of imprisonment. And if this behavior is capable of preventing the efficiency of the protection against a state of danger, then the sanction is a 1 to 5 years imprisonment. The Hungarian Constitutional Court continued to exist, and that remained to be the only check on governmental decrees. However, because the courts didn't operate fully, and because it's extremely difficult since 2011 to turn to the Hungarian Constitutional Court if you don't have a specific case or controversy in front of ordinary courts, it was virtually impossible to take a case in front of the Constitutional Court. But what is more important is that this check was only theoretical, because for a very long time, the Hungarian Constitutional Court has been captured and only serves the interests of the government. But as you say, the proof of the pudding is in the eating, so we should check what the law was used for, what types of decrees were adopted. Altogether, more than 150 governmental decrees were adopted, many of which did not relate to the fight of the pandemic in any way whatsoever. So, for example, the government classified business deals with China. It provided free real estate to a foundation belonging to the favorite historian of the government who contributes to the identity politics of Fidesz. They increased the number of supervisory board members over theaters from 3 to 5, with 3 being appointed by the state. You have to know the background that theaters were very critical, especially theaters of the capital were very critical of the government. So it was a kind of a sanction against them. Another controversy related to transgender people, they were prevented, according to a degree, from having their new gender registered in their official documents. I can't see how this relates to the fight against the pandemic. Also, the government brought a packaging company under state control. Now, the way it happens is that a decree is published on one day, and on the same day, the government commissioner in charge of the company fires the whole board of directors without consulting the stakeholders and replaces them with new ones, the majority of whom are important government members. I don't know why this company was of strategic importance. It was a packaging company, but I think this was also a sign for other companies that this can happen to them under the new law. Another controversial law, and this is my final illustration, created special economic zones in areas that were deemed to be of national importance. In these areas, the local industry tax was not collected anymore by the town municipalities, but by the county administration. This decree was adopted one day, and immediately the next decree declared the city of Good, or a part of the city of Good, such a special economic zone. Now, this is extremely important because in this special area of Good, there is a large Samsung company which pays huge taxes to the local municipalities. And from now on, these taxes need to be paid to the county level. Why is it politically important? Because the city of Good has an opposition mayor, whereas the county is led by Fidesz. Okay, so what were the EU responses to all these series of decrees adopted? I'm afraid the EU acted as if it was a paper tiger. Later, we will discuss that the EU is not, but it acted as if it was a paper tiger and didn't have the competence to intervene. In an interview, one of the commissioners who is responsible for the rule of law said that we would have to wait and see how the increased emergency powers of the government are applied, even though we had ample evidence that they are not using these powers for fighting the pandemic. Then there were 13 member states who call themselves the Friends of the Rule of Law, who issued a statement highlighting the importance of the rule of law when fighting the pandemic. However, for political or diplomatic reasons, they didn't name Hungary. So in a rather sarcastic and cynical move, Hungary joined the list of signatories, thereby rendering the whole statement entirely meaningless and ridiculous. And another commissioner, also responsible for the enforcement of the rule of law, promised to evaluate the new law, but only the criminal law provisions. Now, I understand that these are important changes, but I believe that rule by decree is equally important than the amendment to the criminal law. What simultaneously with all these very lukewarm European responses, talk started about the allocation of money within the European Union, and you have to know that Hungary is a net beneficiary. So it gets more money from the EU than it pays to the EU budget. And several member states and important politicians are now lobbying for connecting the distribution of funds to the rule of law conditionality. If a member state doesn't respect rule of law, democracy, fundamental rights, and other values of the European Union, they shouldn't get the money. And even a new instrument is now proposed within the framework of the European Union to make that happen. Let me have a legal addition to that. Even the current laws, the ones that are currently enforced in the EU, allow the withholding of the funds if a member state doesn't have an independent judiciary. So at the very minimum, you have to have an independent judiciary so that anyone who doesn't have access to EU funds should be able to make it justiciable in front of an independent court. So if there are no independent courts, no money. Unfortunately, this provision has never been used, but I very much urge the European decision makers and institutions to make use of this provision, because as many of my colleagues, including Joël and others, pointed out, this is somewhat absurd that the EU is contributing to with money to the building up of autocracies in violation of European Union values. So probably because of these talks about the monetary disincentives against rogue governments, or for some other reasons that I cannot see now. But in any case, the Hungarian government proposed two bills. The one, it would repeal the Enabling Act. It's a one-page document, basically. And the other one, it introduces a new kind of state of emergency, a state of medical emergency. Once the government proposed to have the Enabling Act withdrawn, the Prime Minister and also the government asked member states, civil society members, and also members of the academia to apologize for calling Hungary an authoritarian regime due to the introduction of the Enabling Act. And in an unprecedented move, it actually sent such a letter to European consulates to ask their researchers to apologize from the Hungarian government. It caused some controversies, as, for example, the Finnish diplomats have never seen such a document reaching them. So in any case, Enabling Act number 2 introduces the state of medical emergency, which is which is difficult to cluster because such an emergency doesn't exist under the Hungarian constitution, the fundamental law. So a medical emergency is somewhere between ordinary times and proper emergencies. And some of our colleagues, including Gabor Halmai and Kimlein Shepeli, they say that this law is even more dangerous than the previous one because it doesn't have any parliamentary oversight anymore. The emergency is introduced for 6 months, but it can be prolonged again and again indefinitely. Also, an important point is that the decrees, the governmental decrees that are adopted under enabling law number 2, they don't lose. They are not. They remain in effect even beyond the state of medical danger. So I don't know whether it was deliberate or just a poor codification technique. And also, it introduces measures that can significantly limit fundamental rights, such as, for example, a government body can treat our personal data into a very wide extent, way beyond medical data or personal data absolutely needed for the fight against the pandemic, without, again, a temporal limitation. So as the scholars named highlight, the operation of all institutions, programs, or activities that could promote the spread of the epidemic can be suspended under the new law. And the wording is so vague that we don't know what institutions really are meant. The Hungarian wording would really cover the suspension of courts even, or political parties, or the parliament. So we don't know. We really have to see how this will be applied in the future. And I have a couple of minutes to address the EU legal responses here. Now, there have been arguments presented against the EU interfering way before the Enabling Act entered into force. And there are some quite persuasive counter-arguments against EU action. One is that it's not an external body like the European Union that should interfere, but much rather it's the people who are supposed to change their government if they are dissatisfied with them. Now, this is a persuasive argument, but how can the people change their government if the elections are still free, but according to international observers, they are not fair anymore in the country? There is substantive gerrymandering. It's virtually impossible for the opposition to win, not least because of the distorted media landscape. So people don't have access to information anymore, or opposing information anymore. The other counter-argument is that the EU shouldn't push too hard or too harshly because then the governments may, in the end of the day, secede from the European Union. And indeed, the Hungarian government is already toying with the idea of secession from both the European Convention on Human Rights and the European Union, especially if the funds are not flowing in, the money is not flowing in. Well, this is the good old Council of Europe argument. It's better to have countries with very poor human rights record to have in the Council of Europe, because at least then you have some influence. Now, the question is a matter of balancing, I think, here. How far you can go with an undemocratic entity within a quasi-federation without really harming the EU federal structure. We have already seen that rule of law violations become contagious. They spread to other member states, and perhaps we will talk about this later, but they also endanger fundamental EU legal concepts such as supremacy or direct effect. And there is a third counter-argument saying that the European Union doesn't have the power to interfere. Now, if you look at the treaties, Article 2 of the treaty that lists the values that the European integration is based on, that all the member states promise to respect and also to promote. but also to Article 7, the sanctioning prong in case these values are not respected. You will see that the EU doesn't only have the power, but has an unequivocal obligation to interfere in case the member states they do not respect do not respect the trinity of the rule of law, democracy, and fundamental rights. So I think my 20 minutes are over, so I will stop here, but I'm very open to discuss the actual tools that the EU could make use of if there was a political will to make use of them. Thank you.
Thank you very much, Petra. That was an extraordinary presentation and most informative and educational. Boy, what an uplifting set of facts you presented there for us. I'm not sure which to address first, though it seems from your presentation that the points that are in play were not a sudden response to the pandemic, but have been accretive over time from the institutions that have been put in place, from the various now decrees, you're saying in Enabling Act, Law Number 2, to the lack of an independent judiciary, which you're saying is an arm of the government, to various expansive acts of the federal government, including now, very disturbingly, criminalization of what sounds like free speech or the ability to criticize government policy. So those are, seems to me, evidence of a governmental system that is really inconsistent with the rules of and principles of the EU. So I understand the counter argument that you make, but is there not a more robust movement to enforce the principles of the EU and hold Hungary to account, irrespective of its qualification for financial contribution?
Yes, you're absolutely right. What happened in the past decade in Hungary is irreconcilable with the values that the European Union is based on, and that Hungary itself promised to respect and promote when signing the Lisbon Treaty, which is the quasi-constitution of the European Union. There is a legal technicality that I haven't addressed so far, and it relates to Article 2 of the Treaty on the European Union, which is part of the Lisbon Treaty, as we call it. And according to Article 2 Article 2 listing all these wonderful values, such as the rule of law and fundamental rights and democracy, they cannot form the basis of secondary legislation. So they cannot form the base. You cannot base a European Union law, a regulation, or a directive on Article 2 directly. Whereas you can base a secondary legislation on any of the other provisions of the Lisbon Treaty. But this is a legal technicality, and it's not the same thing as enforcement. The fact that it cannot be a legal basis doesn't mean that it's unenforceable or not justiciable. Of course it is. So I think this is one of the misunderstandings surrounding the whole problem. The second problem is that the treaties were not designed to respond to a rogue government. It wasn't foreseen for a very long time. Well, first of all, human rights, for example, they were not introduced in the treaties very early on because it was supposed to be an economic organization, right, in the 1950s. But it very soon it turned out that also an economic organization can violate people's fundamental rights. And then the Charter of Fundamental Rights was adopted, and also it turned out that the values need to be listed. And also a very symbolic provision, the famous or infamous Article 7 was introduced into the treaties, according to which if a member state fails to respect these values, then in the first round, it can be determined, such a violation can be determined by the institutions, or a threat to these values can be determined. And in the second round, once it's not only the threat of the violation is there, but once the violation already occurred, that can also be determined by the EU institutions, and sanctions can be attached to this violation. Sanctions can be different. Earlier, it was only suspension of the voting rights in the Council, but now the Lisbon Treaty talks about the suspension of other rights flowing from the treaty. So here the institutions could be super creative in thinking of dissuasive measures for the member states. However, Article 7 is a very political provision. So you have to have, especially for the sanctioning prong, you need to have unanimity in the institutions, minus the country against which the proceeding is conducted. So as the scholarship says, Article 7 was not drafted so that it can be invoked and so that it can be used. It was only inserted into the treaties as a threat. No one thought that it would actually be used. There is another problem, and this is the following. Even if Article 7 is used against a member state, the drafters didn't foresee more than one EU member state abandoning the path of the rule of law. So now we have two member countries, namely Poland and Hungary, against which Article 7.1 proceedings have been started. Article 7.1 is the first prong, so it only determines that there's a threat of a breach of Article 2 values. But even this procedure is very lengthy, very burdensome. We never know whether it will ever come to an end. But if we reached the second prong of Article 7, for which unanimity is needed, Mr. Kaczynski already promised Mr. Orbán that it will veto the sanctioning procedure and vice versa. So if there are at least two member states which are problematic, you cannot trigger Article 7.2. Of course, in the academic literature, we have very creative suggestions, such as, for example, let's start an Article 7 procedure simultaneously against the two countries so they cannot vote in the joint procedure. I'm not sure whether the treaty allows this, and I'm pretty sure that the member states which are the respondent states in this case would challenge this in front of the Court of Justice of the European Union. So this is the second problem. Article 7 was never there to be used. And there's a third problem. Every member state has some rule of law issues. So they very much fear an annual regular rule of law scrutiny in the European Union, because they might be also subjected to a rule of law procedure which everyone wishes to avoid. So they believe that once you have such an annual scrutiny that we can talk about later, I also contributed to the European Parliament's work on such a scrutiny. So once you have such an annual health check of the rule of law in place, these member states might also enter, or all member states might virtually enter very uncomfortable situations that they try to avoid.
Wow, well, you've certainly identified and amplified the kind of structural vulnerabilities of the EU for member nations that have problems with, but on a very different scale, with claims of application or adherence to rule of law. But this begs a kind of a supplemental question to the one I just posed by one of our participants. So if there are infirmities with existing available tools, in your view, and in light of your experience and contributions, what would be and how would the EU build a robust response towards Hungary, even by creating new tools, new ways to help preserve core EU values, including the rule of law, human rights, and an independent judiciary? What should the requisite political will be focused on to address the problems in Hungary? So I know this builds on what you've already been addressing, but there's added interest and concern about these issues.
Thank you very much for this question. This is the issue now, I think, within the European Union. And indeed, all institutions, all political institutions, and now I mean the Council, the Commission, and also the European Parliament, have been developing and fine-tuning their own instruments on member states' compliance with the values the EU is based on. Now, this resulted in a very unfortunate power play between these institutions, who does what. And the emerging picture is one of competing tools with different institutional actors claiming to know best how to go on about Article 2 threats and risks. I very much favor the European Union, the European Parliament's approach. The European Parliament will now come up soon, and we had a discussion just yesterday about this in the EP. So they will come up with an interinstitutional agreement between the three institutions, emphasizing the triangular nature of the rule of law, democracy, and fundamental rights. In contrast, the Commission would only focus on the rule of law separately, on fundamental rights separately. So I think the triangular nature is extremely important. Democracy without the rule of law is just a dictatorship of the majority. Human rights without democracy and the rule of law, it's not enforceable. So, so they really are interrelated. Or just think about a recent problem that is my narrower field of research, and this is mutual trust and mutual recognition, according to which member states are supposed to acknowledge each other's criminal law judgments. But how can you acknowledge another judgment if you cannot be sure that the person has been tried and sentenced by an independent judiciary in a fair trial? So now member states which are democratic and their judiciaries, their national judiciaries, start not to recognize judgments coming from problematic countries. Is it a rule of law problem or is it a fundamental rights problem? It's a rule of law problem because it's independent of the judiciary, but the way the EU's court defines it, it's a fundamental problem partially because the suspects do not have a right to a fair trial respected. So these issues are all interconnected, so I very much favor the European Parliament's approach in that respect. What is also important is that such a scrutiny, which will now definitely be introduced, should have a firm legal basis. If the member state cannot challenge the criticism, it will challenge the critique. And it will say that they are politically biased, that the people who are sitting in the committee making the analysis, they are political appointees. So it's absolutely crucial that there is a solid treaty basis for the committee doing this scrutiny. There is legitimacy, there is accountability, various sources feed into the system. So of course, not only information from the government, but also there should be shadow reports from civil society, from academia. There should be the very neutral decision-making body at the core of this regular context-specific analysis. Now, the Commission wants to do this analysis itself, but the Commission in the past years identified itself as a so-called political commission. Now, it doesn't do good for a rule of law scrutiny because it will immediately be criticized as being political. The Parliament came up in a very creative way with the so-called Copenhagen Commission, referring to the Copenhagen accession criteria that member states have to respect when they accede to the European Union. So this kind of Copenhagen Commission should consist of former judges, constitutional court judges, Supreme Court judges who are not anymore in office in their respective countries, and people from academia. This is an interesting suggestion, I think. The next thing that that such a committee would have to do is to make a context-specific analysis of the situation. What rogue governments are often doing is that they borrow from other jurisdictions. And then they say, well, this is just an international practice, what we are doing. But someone who is only doing a superficial analysis will not notice that they are selecting diverse practices from all over the world, the most rights infringing practices. And as Kim Lane-Shapley said, a Franken-state is in the making. The worst elements of all countries are put together, even though true, there are international examples. And also the international examples are taken out of context. I remember once I was asked, what is the lowest age of criminal culpability in the European Union? But that doesn't matter, because someone who is tried and sentenced at the age of 11 in a common law country will get psychological support. Sociologists and social workers will surround him and the family and will not be imprisoned. So you have to understand the context in order to assess a so-called legal transplant. Also, what these committees should learn from the Hungarian rule of law decline is that time is on the side of those who want to dismantle the rule of law. Later will be too late. So there needs to be a prompt response to rule of law backsliding. At the very minimum, infringement cases in front of the Court of Justice of the European Union that deal with member states' violations of European Union law, they should be accelerated, they should be prioritized, and there should be interim measures imposed so that the member states cannot continue with their state capture or constitutional capture. And finally, this is my last response to your question, or to the colleague's question, is that many politicians, and definitely the whole Commission, or the vast majority of the Commission, but also many members of the European Parliament, still believe in a discursive approach. They want to have more consultation, more debate, more deliberation, which is very useful, and it might work well with member states that voluntarily respect the rules of the game and they adhere to the concept of a liberal democracy. But when it comes to countries who do systemic rule of law backsliding, the effectiveness of the EU reaction hinges on its response or the enforcement prong. Unfortunately, the Commission says that first promotion and prevention should be in the focus, and response should only be a last resort. I understand the logic behind this, but if the response prong is not strong enough, if it's not dissuasive and it's not effective, the sanction that is imposed on rogue governments, then we just engage in a very long and fruitless discussion with a rogue government, which gains even more time to complete the constitutional capture.
Well, thank you, Petra. One tangent to this, it strikes me that kind of irrespective of the European Commission or Parliament's response or any measures they may undertake, is that actions that you've outlined by Hungary may well implicate bilateral relations, especially with respect to criminalization of conduct, of behavior, of speech that is not recognized by other nations, even outside of the EU. And that may implicate issues, for example, with respect to a mutual legal assistance treaty and how newly enforced crimes are enforced or treated by other nations that otherwise have an MLAT or bilateral treaty with Hungary. Are there measures that these other nations can take outside of the EU through trade or legal enforcement or other pressure bring to bear to kind of reshape or help reposition Hungary's approach to the rule of law?
Well, this is really beyond my field of expertise, but I know that now there are talks about an e-evidence directive within the European Union, and this is basically the counterpart of MLATs that might be issued if there is a cross-border element to a crime. And here there is a vital problem behind this e-evidence directive, namely that it is supposed to be based on mutual trust and mutual recognition. But mutual trust is supposed to function within, between member states, governments. And here we are talking about private entities. So why should a service provider trust the Polish government, let's say, and its judiciary? And what is more, why should a service provider or an IT company, and we don't have to think only about the giants here, but also there are small ones which do not have the capacity to check whether complying with one request would lead to the violation of individual rights or not. So during the negotiation phase, the giant companies were there at the negotiating table. And what I learned from US companies is that they just simply do not respond to AMLETs with regard to free speech, also because of the different understanding of free speech. So it's not necessarily because of rule of law decline, but also because free speech has a different status in the American legal system than in the European one. But it's certainly part of the problem, and this might have a dissuasive effect on these member states. But not only if the US doesn't recognize such requests and doesn't comply with it, but also within the European Union. If suspects cannot be extradited to another country, this is certainly a problem. And this very much goes against the concept of EU criminal justice. But what is more, the lack of trust or distrust among the member states might infiltrate into civil law. And I think this might have harsher consequences, because an independent judiciary is not only important for criminal law, but it's equally important for the existence of the Eurozone or the single market. And if civil law contracts are not recognized by judiciaries and they are not enforced, then this is going to be a problem. I cannot say much about this because I was an expert witness to a case. But there was a third country which had a case against the Polish government in this case. And the question was whether the International Commercial Arbitration Tribunal has jurisdiction at all. And in this case, the tribunal accepted that the client wouldn't get a fair trial anymore. Not a fair trial, but there wouldn't be an independent judiciary in a civil case that would provide remedy for a third country company against the Polish government. Now, of course, there's a confidentiality clause. We can't say too much about this case, but if this logic is also applied to ordinary civil cases in front of ordinary courts, then this is the end of the single market. And that might be much more dissuasive than an Article 7 procedure, for example.
Wow, fascinating. Well, this has been a fascinating discussion. There's one more a question from one of our participants that I think touches on what you're talking about, also on kind of civil obedience to laws that are imposed by governments with respect to the pandemic. And Petra, I would open it to you first, and then also to Joelle, invite her comments on this, because I think this is a broad question that both of you would be readily expert and able to address. And the question or questions are this is one, in terms of the contention that institutional or social support is necessary for the rule of law, how do you assess a measure of misbehavior at the margins to be consistent or inconsistent with the rule of law? How does that how much misbehavior at the margins is consistent with saying that the rule of law prevails? How much misbehavior can a system withstand? For example, whether they're speakeasy bars or they're secret hair salons or other day laborers. What happens when a government attempts to go too far, essentially, in the views of its societal members, to enforce a quarantine that is very difficult, if not impossible, to adhere to.
Shall I start?
Yes, please.
Okay. Yes, this agreement with the government on the side of the population is extremely important, and I think one of the excuse me, one of the tragedies of the Hungarian society is that civil society has never been strong, even after the democratic transition. It hasn't been strong, so there was nothing that we could have built on. I think this is one of the vital differences with regard to Poland. When the Polish judiciary was dismantled, you could see huge masses go out to the streets. They were chanting independence to the judiciary, and Professor Sadurski, a well-known constitutional scholar who himself is harassed by his government, gave a constitutional law speech on the stairs of the Supreme Court. You don't see things like that in Hungary. So I think this is very problematic, and we are not talking about civil disobedience here, but we are talking much more about self-censorship. So I see an opposite phenomenon. The government basically attacked all segments of society, those who were anyway traditionally disadvantaged by the majority, such as the Roma, the suspects, the convicts, the LGBTI community, and so on and so forth. But anyone who is out of the ordinary. So my most bizarre example is women who wanted to give birth in their homes were attacked, and there was a witch hunt against them just because they are different than the ordinary Hungarian. So they want to homogenize Hungarians, the Hungarian nation, as if it was a homogeneous one, which I very much doubt. So my problem is that all these attacks against certain segments of society, and many of these attacks are legal attacks. These are slap cases against journalists, investigative journalists, against academics, against ordinary people who just voice a government criticism on social media. So unfortunately, these cases lead to an extreme self-censorship on the side of the population. So I wish that the problem was civil disobedience, but it is not, it's rather the opposite. And what I'm also missing from the debate is other member states, citizens being aware of what is going on in Hungary. Now, this is also on a political note, but when one German politician was who was supported by the Christian Democrats, CDU, CSU, was elected with the help of the AfD, the right-wing radical party, there was a huge outcry in Germany, and it led to a political scandal, and several politicians had to leave office. When Ursula von der Leyen, the president of the Commission, was elected with the support of the Fidesz members, of the Hungarian government members, who are clearly in denial of EU values, that was no problem at all. It was cherished that now a compromise has been found. Why? Because the German voters, they do care about what is happening to the AfD, what is happening to their party, the Christian Democrats, and they don't want to intermingle with right-wing radicals, but they do not really care what is happening in Hungary. There is no political outcry. The basic point is that finally we have a president of the Commission elected that we are happy with. So I think awareness raising throughout the European Union would be crucial. Thank you. Stop here.
Great. Thank you very much, Petra. Joelle, would you care to comment on the participants' series of questions, or any one of them?
Absolutely, absolutely. I'm first going to do that rhetorical device of reframing the question before I then answer it, which is first talking about misbehavior at the margins. I would actually primarily be concerned about misbehavior at the center. The prime aspect of the rule of law is not necessarily to regulate the behavior of the ordinary citizen, but to ensure the institutions, the government, the judiciary, the executive, that they are compliant with the law, that they are subject to the law, that no one, no institution, no prime minister, no governor is above the law. So my concern throughout my research is misbehavior at the center. But that was not your question. It's misbehavior at the margins, which actually talks to the degree of compliance with the law. Now, I like that you mentioned speakeasies because I have no like local context of what a speakeasy is. So I'm imagining like 1920s prohibition era. But I did also appreciate the hair salon because I keep referring to my Rapunzel hair that I have going on. But to be more serious, there's always a question of degree of compliance. And the one absolute truth of social distancing measures and any kind of measures that we're seeing that are being brought in terms of COVID is it requires the greatest majority of the population to themselves choose to follow the law. In reality, you cannot police a population. I realize there's very significant, very important questions about who qui custodies, my ipsos custodies. My Latin is not that good, but essentially who guards the guardians. But in the greatest possible extent, you require the highest degree of compliance. Now, the one country that I'd like to raise in this context is New Zealand, because they are one of the first countries to exit restrictive measures. They have had no deaths in the last few days. They have been the poster child of an approach which is based on trust and transparency, and to the greatest extent, very limited misbehavior at the margins. Now, the reason I raise it is they have very, very limited legal restrictions on movement. In reality, the majority of the measures that were introduced were actually social nudges. It was essentially the Prime Minister coming out, so Jacinda Ardern coming out with other ministers of government and saying, this is what we need you to do. This is not legally required in a way that we would recognize it in terms of criminalization or prohibition or mandatory requirements. This is social nudging. This is do this because it is important. Do this because it is important for the community, for your family, for you individually. So when I see questions of misbehavior at the margins, yes, I first think, well, we should really be considering misbehavior at the center, because promoting high degrees of compliance with the rule of law at institutional level, at the point where there is most power and most control of power, tends to lead to higher degrees of trust in the use of that power. And if you trust, if you as an ordinary citizen, you as an ordinary person within this legal system trust the system, then your misbehavior is minor. It's jaywalking as opposed to running a legal salon without gloves in the middle of an emergency. You can really tell I'm thinking a lot about my hair.
Well, thank you. So those are core, not the trust and transparency are certainly core of the rule of law, but here they're exercised in a way that is discussed to the public and made clear with a rationale for it. And if people say, well, look, this makes sense to me, I have trust in the government as being forthcoming and forthright and telling us what it knows, what it doesn't know, and what it thinks makes sense, but we all have to really voluntarily participate and be our own self-enforcers. Well, the example that you gave of New Zealand just highlights those principles to great effect, and lessons that we all can take in all our respective homes and nations. So I thank you both, Joelle and Petra, so much for this really these illuminating presentations and discussions. This was just an extraordinary panel, and I thank Jus in the itinere, and I would like to turn to briefly for the final concluding remarks to Claudia Carbone, who is a member of the European Affairs Committe, and with many thanks for all her efforts in bringing about this most successful collaboration. So I wish everyone well, good health, continued success, and keep safe, everyone. Thank you to all the participants. Claudia?
Thank you, Jonathan, and City Park for the interest in this panel. I would like to thank you so much, the professors Petra Part and Joel Grogan, for your extremely extremely fascinating presentations. And thank you to Silvia Casu and itinere and all the organization that there was behind this event. And thank you very much for the participants, for the engagement and the questions they asked. It was really important to me to organize this panel, to discuss also during this time and during this particular time where it seems that the state of emergency could justify kind of any actions by the state and give them like too much power sometimes according to our constitution, how it's important also to discuss among like professors, among lawyers, and among like citizens or like people interested in the topic, discussing the rule of law and the importance of fundamental principles and democratic values that at the end needs to be protected, especially now where we are in a state of emergency or a so-called state of emergency to protect our democracy and our rights as individuals and as citizens. So thank you very much. Thank you, everybody. I hope like everybody enjoyed it and be well and take care. Thank you.
Thank you.
Thank you.
Thank you. Bye, everybody.
Thank you. Bye.
Bye.